personal data is relating to an identified or identifiable person. Now, there is another category within the GDPR. There's sort of this general and broad definition of personal data, and there is another definition of sensitive personal data. And you might ask, why would you have a definition of personal data and then, another definition of sensitive personal data? And it's because some of the obligations of the GDPR relate broadly to personal data, and then some of the specific obligations of the GDPR and some of the specific rights to a data subject under the GDPR relate to sensitive personal data. And if you at least kind of keep this in mind, the more sensitive the data, the kind of higher degree of responsibility that the data controller or the data processor is probably going to have, and sort of the greater level of rights the individual is going to have. If you think broadly about categories of data that might be considered sensitive, they include some things you might intuitively think about: race, political opinions, sexual identity, religious and philosophical beliefs, health data, things like that. There's at least one or two categories here that you might not intuitively think of: trade union membership, and that relates to other laws in the EU about not discriminating against people who belong to unions. Genetic information, you might think, and biometric data. So all of these things are considered sensitive information, and there are further protections that will apply. Now, some of the conceptual terms, and we've mentioned some of these really and have been dealing with them throughout the day, but you really want to have these sort of deep into your bones as you take this exam. So the data subject, any natural person whose data is being collected, stored, or processed. The data controller is the person who is determining the purpose of the processing. And the data processor is the entity that is doing the processing. And as I said in our first session, that could be the same entity, or it might be different entities. And with any given company, it could be that sometimes the company is acting as the controller and the processor, and maybe sometimes the company is only acting as the controller and has a third party as the processor. Maybe sometimes the company is acting as a controller with some information and is providing services, processing services to others with other information. So, given all that, why do we care who's the controller, who's the processor? There are some different obligations in GDPR for each. And for this test, you don't need to know those in detail. For the SIP-E, you'll need to know those distinctions in detail. But what you should really know is that the most basic responsibility falls with the controller. So the controller can't simply outsource its duties to the processor. Now, the processor, by taking on that responsibility, is taking on also some duties. But both the controller and the processor are going to have responsibilities. Okay, so what are the requirements within the GDPR? One of the core requirements in the GDPR is this idea of consent. So the data subject has the right to consent to whether and how their data is going to be processed. Now that differs somewhat from the general US conception, in particular in that the GDPR is a comprehensive regulation. It applies to every industry, to every sector throughout the EU. If you take the SIP-E exam, you'll learn a little bit more about the way the EU functions if you don't know already. But in general, it's a sort of quasi-federal system. There's a rough analogy to the US federal government and the state governments, although there are very, very significant differences. The member states within the EU retain their own sovereignty. They have their own laws and their own customs. But within the treaty that binds them together within the EU, they agree to certain common sets of principles and common sets of laws. So within the EU, you can have a kind of law that is only providing a standard in which then each nation state has to enact their own national law consistent with the standard. And there frequently are disputes that can eventually be heard in the European Court of Justice about whether national law is in fact consistent with the general standard. At a higher level, you can have a regulation, and that is in fact what the GDPR is. So the lower level is called a directive. The higher level is called a regulation. Before the GDPR in the EU, there was a privacy directive, and there were lots of questions about whether individual member states were really adopting national law consistent with the directive. A regulation is law in all of the member states as is. So there is not implementing regulation within a member state that can sort of broadly interpret what the directive is actually saying. There's not as much play in the joints for the member state of a regulation, and that usually shows that this is an important EU-wide policy. Okay, so the question of consent in the regulation, which means now that every member state has to have this concept of consent, freely given, specific, informed, unambiguous indication of the data subject's wishes. And that is generally interpreted to mean an opt-in consent. And so this is a really key feature that distinguishes the GDPR. First, that it is comprehensive across all sectors. And second, that it requires opt-in consent. So this means if you are processing the data or controlling the data of EU data subjects, then you have to have an option where they affirmatively are opting in and giving the consent to the specific kinds of processing that you are doing. Now, many of the privacy obligations, the sectorial privacy obligations that we've looked at under US law vary here. Some of them can have opt-in requirements. Some of them can have opt-out requirements. And that can be a really significant difference if you are the controller or processor. It's much more of a burden to make a disclosure that requires that the subject opt in than to make certain kinds of disclosures and then just leave it. As so long as the subject doesn't opt out, you're okay. Now, even under an opt-out regime, you have to have some real opportunity to opt out, but it can be a pretty significant difference. And as we will see, the various states that have begun to adopt comprehensive within their states privacy legislation vary on whether they're requiring opt-in or opt-out. And as we've kind of discussed throughout the day a little bit, this notion that the US federal law does not have a comprehensive federal privacy statute. And one of the political questions for how that ought to be structured, if in fact we should have one, is this question of, well, should it be mandatory opt-in or not? Okay. And so this is the fact that it's an affirmative statement that in fact it is opt-in. A couple of other concepts within the GDPR that might be a little less intuitively familiar if you kind of haven't heard them or worked with them before. The first is the idea of a data protection authority, or DPA. So the GDPR establishes that each of the member states, each of the EU member states that are bound by the GDPR, must appoint at the national level some government authority that functions as the DPA. And so that means that at the national level, if you are a German citizen who is a data subject and you have a complaint or dispute or question with regard to how your data is being handled, you have a central authority within Germany, the German DPA, that you can go to and begin to initiate a process to deal with that complaint. And those authorities are authorized under GDPR to conduct investigations, to begin proceedings, and the like. And again, if you take the SIP EU, you will learn in more detail about the obligations of the DPAs but you at least should know for this exam that they exist and this is what they do. And then also is the idea of a data protection officer, or a DPO. So the DPO is any process controller or processor's point of contact for the organization, who can then interface with the DPAs and otherwise interface with the authorities that they need to in relation to GDPR. So the DPO could be an employee of a company. It could be a special kind of new hire or new office within the company. It could be some existing person like a CISO or an auditor or somebody else who takes on this role. But it is a specific role, and it requires some specific knowledge, that the person has some specific knowledge and training, and that they be accessible and have the authority to make the reports within the organization that they have to make. Again, the details of that, SIP-E, the general concept, is something you ought to know about. And you also want to know that if you are an entity located outside the EU, you still potentially have obligations under the EU if you are processing data of EU citizens, which is, for many businesses doing business online, not unlikely. There's a good chance you do have some of those obligations. Then you are obligated to have a DPO who is able to interact with the DPAs in the EU. The state or the U.S. Statutes that we've looked at, the sectorial statutes that we've looked at, generally don't have DPO specific requirements. Now, many of them will have, like Bramlage-Bliley is this huge statute. It does have numerous audit and reporting requirements that only a small fraction of which are going to relate to privacy. So there's someone in an organization who's going to have that responsibility. But this is sort of an innovation or a concept that there's a specific national authority to handle the complaints and other issues, and that there's a specific individual in any entity, any processor or controller who has this role. And in a lot of ways, this is good for privacy compliance. And it's also really good for our profession because, folks like you, like all of us, can, play this kind of role in an organization. All right, so some of the basic general principles of the GDPR, and you should begin to, and this is one reason I put this piece at the end of our whole discussion. We started out kind of general and broad, and then we dove into the details of these very specific areas. And now that SIP-E, you dive into detail of GDPR, but looking at these principles, we're coming back out to this broad sense. And even though these are GDPR specific principles, they are based on the FIPS, the Fair Information Privacy Standards. And so these ideas really weave their way into pretty much any data privacy regime you can think of. So lawfulness, fairness, and transparency. It means that the data is only going to be processed for a lawful purpose. And what does a lawful purpose mean? Well, the GDPR is going to specify, at least in the general categories of things that can be lawful purposes. And this idea of lawfulness, really ties back to this idea of consent. So it is lawful to process if you have opt-in consent and you have some business purpose. There are other things like, if you're subject to a government investigation and you need to disclose some data. There is even within the GDPR a sort of purpose balance test, even if you don't have opt-in consent. So you drill into those details when you do SIP-E, but really know that lawfulness is there's some requirement that you need to supply this data, like a government investigation, or you have a business reason and you have consent, or if you don't have consent, there's some really good balance to suggest why you didn't get consent. In general, the practice is you really need to get consent. Purpose limitation. So you have a lawful, fairness and transparency. So the manner in which, it's not simply the purpose for which you're processing the data or controlling the data. It is the manner in which you are using the data. So you're not using it in a way that unfairly discriminates against classes of consumers, or that unfairly impinges on someone's civil rights. I'm not going to sell to XYZ kind of person, something like that. And transparency. Now, of course, transparency doesn't mean that the company has to disclose the family jewels, all of its trade secrets to the world. I mean, Europe has a reasonably robust trade secret regime, a little different than the US, but reasonably robust. So it doesn't mean that, but what it means is, as to the data subject, you're being transparent with them about what you are doing with their data. And this, of course, ties into the notion that you have to make disclosures. We've talked in different parts of the US laws about privacy notices and stacked privacy notices and things like that. So the GDPR goes into some specificity about the kinds of notices that you need to provide so that you're being transparent to data subjects about what you're doing with their data. Okay, purpose limitation. So purpose limitation means that you are doing with the data what you need to do with it to accomplish your lawful purpose, and nothing more. And really, in many ways, this relates to kind of a good data hygiene practice. And we often talk about the principle of least privilege in data privacy and security. And in many ways, this is really a data security concept. But the idea is, if someone is going to have privilege to look at certain data within your organization, you give them the privileges they need to do what they need to do, and nothing more, right? So there's some task they need to accomplish that's part of your business. They need the privilege to accomplish that task, but they don't need to be looking at that data for some other reason or for some period of time that they don't need it. So a similar kind of idea. You are the controller, or you are the processor. You are doing what you need to do with the data, but you're not doing more. You're not using the data for something more than you need to be using it for, given your purpose. Related to this is data minimization. So, you've got some sets of data that you need to do your business. Do you have other things within the sets of data you've collected that you really don't need? And, this is in kind of doing privacy compliance. This is always a red flag. In doing data security compliance, this is always a red flag. You've got sort of piles of data stored in different places, and you're really not doing anything with them. Now, it's not that there's something sort of inherently wrong with that, but it's a problem waiting to happen. It's stuff that's waiting to be accidentally disclosed that doesn't need to be, because you don't really need it. So data minimization means being really careful to kind of try to go through the data you have, to get rid of stuff you don't need, to anonymize when it's possible to anonymize, and things of that nature. The accuracy of the data. So the accuracy of the data means that the data you have relating to a data subject is accurate. Now, of course, there are limitations to this. I mean, if the data subject is giving you inaccurate data, that's potentially a problem. But this will also relate in a moment when I show you the rights of the data subject. And one of those rights is to see what you have, and if there's something mistaken, to correct it. Storage limitation, and this relates to purpose limitation as well as to data minimization, which means the time period in which you're storing data should not be infinite unless there were some reason to make it infinite, which seems hard to conceive. You could have a reason that requires you to keep data for a relatively long period of time, but it should be tied to a specific business reason related to what you have disclosed to the subject. And otherwise, there should be times when the data that you're storing expires. The integrity and confidentiality of the data, and these also relate to these other pieces like accuracy and purpose limitation. So the data that you have is kept in a way that it doesn't become corrupted, it doesn't become garbled and the like, and it's kept in such a way that you are paying attention to good data security practices. When we do our we do a large privacy and data security boot camp that's a week long in the spring, and if you might be interested, we'll have information later in the year probably about that. But we talk there about cybersecurity and about data privacy. And one of the things I try to emphasize with that is that it is possible to have data security without privacy. And what does that mean? You could keep all the data you have secure, so it's resistant to a data breach, but you're really still not observing all of privacy best practices. And it might be, for example, that people in the organization who don't need to see certain stuff are seeing it, or the storage limitation isn't being observed. So you could have that. You can't have privacy without security, because if the data is not secure, it's going to get exposed and likely to be breached. And if it's breached, you lose confidentiality. Now, one thing I just want to point out here is an acronym you might see come up. You won't see a specific test question about it, but you'll see the concept and perhaps even the phrase come up, which is CIA. And again, I'm trying to write with my mouse. So within data security and data privacy, we use this acronym: confidentiality, integrity, and availability. It's a memorable acronym because it sounds like the Central Intelligence Agency, which it's not. But basic principle: we want to keep information, our data, confidential. We don't want it disclosed to where it shouldn't be. In doing that, we want to preserve the integrity of the data. If the data is getting corrupted, if it's getting scrambled, that's really not useful. And in doing that, we also want to preserve the availability of the data for the purpose for which it is rightfully being used. If we can keep data perfectly confidential by encrypting it and throwing away the decryption key, but that's not useful, right? That really destroys its integrity. All you can read is ciphertext, not the plain text, and it destroys its availability. So you want to kind of keep in mind all of this ties into the CIA triad, and they're broad general principles that apply to really everything we're talking about. Okay, so what are the data subject's rights under the GDPR? And here is kind of a summary list of those rights. I noted already the right to be informed. So this is a requirement of privacy notice, and again, GDPR drills into some different forms and requirements about that. And so I think intuitively, everything you've heard today, you should always be thinking a right of notice, a privacy notice, knowing what the processor or controller or processor is doing is pretty common to a lot of different data privacy regimes. You might not immediately think of these, but they are important in the GDPR, and they're areas in which a sectorial privacy law may or may not address, and there are areas in which the comprehensive state laws will address, and discussions about whether there should be a federal law, US federal law will address. So right of access. In the GDPR, the data subject has a right to go to the controller or processor and say, you have given me notice you're processing my data. I've presumably consented, otherwise it wouldn't probably not be lawful. I've opted in. I want to see the data that you have on me. And the controller is obligated to provide that data in a usable format to the subject. So this puts an obligation on data controllers to have the technological means. So their data governance system internally needs to be set up in such a way that it is feasible on, and with a relatively short turnaround time to collect the data they have on every individual data subject, and that could be millions or tens of millions of individuals. A right of rectification. So this is the right of the data subject to accuracy and to make corrections. So you're controlling and processing my data. I ask to see what you are doing. I look at it. I see my address is wrong or something like that. I can ask you to correct it. And again, you have to have the means set up technologically to make those corrections. And as we're talking just kind of briefly about that, it sounds like, okay, that's not that hard. I mean, if you were to send me a message right now and said we had your name wrong on the program, we can correct it. But again, you're talking millions, tens of millions, perhaps more of individual data subjects. And it could be in a large organization where this data is spread out all over the place. It's data most likely hosted in various places in the cloud. It is a big exercise, a big obligation to do some kind of audit and figure out where all the data is and map it all and set it up in a way that this is really gonna work. All right, right of erasure is related again to access and rectification, and properly called the right to be or popularly called the right to be forgotten. So this means the data subject can say, all right, I understand I had opted in, I had given you consent to process this data. I no longer want you to do that. And not only do I want you to stop processing my data, I want all of my data that you are holding destroyed. And the controller or processor has an obligation to try and effectuate that. And again, that can be really hard. There have to be systems set up and really from best practice, from the outset, established with this in mind, knowing that you're going to have to maybe be tracking down many different places to try and make this happen. Right of restriction on processing. Now this can be a really tricky one to comply with because a data subject might opt in, so you can process my data for certain purposes, and might later decide, all right, it's okay with me if you're still processing it for this purpose, purposes 1 and 2 that I had consented to, but now there's purpose 3, and I really want that to be restricted now. And again, there are details and ins and outs of exactly how and what constitutes an effort to comply with this, and when the data subject can ask for it. But know that there is this right, and this right does, in fact, impact some of this U.S. state comprehensive privacy statutes. And I think this is really, the right of access and rectification and right to be forgotten. These are real burdens, and there are areas in which there are, policy debates, lobbying debates, and the like about whether we should have comprehensive U.S. federal responsibilities because they put an obligation on the processor or controller. I think in some ways the right of restriction can be even more of a difficult one because then as the processor or controller, you're in the situation of having to figure out how you're going to set up your product or your service in a way that you can deal with this but can still continue to broadly offer the product or service. And very often the right of restriction comes along with related rights to not suffer discrimination as a result of requesting the right of restriction. And this can be really difficult. I just last week did a presentation to some people in the gaming space. So, casino gaming, sports betting, sports industry, things like that. And the California statute and the Colorado statute have restrictions like this. The problem is, though, if you have a gaming app, say a sports betting app, and part of the way you're sort of setting odds and collecting and administering what the person is doing is based on the information that's being given through the app. If somebody asks for restriction, can you continue to provide that service? on a non-discriminatory basis. I think it's in some cases, a very hard obligation to comply with. All right. Right of data portability means that the data subject can, since they have access, they have the data in a format, the requirement to receive the data in a usable format. And that format has to be something that the data subject can then take somewhere else if it wants to. And the data subject has the right to do that. So it might be that I'm using, your online casino service. I really don't gamble, but if I did, right, I'm using your online casino service, and I decide that I want to use another service, and for some reason it would be convenient to me to take the data that you've accumulated about me and give it to that service. I have the right to do that. And that's a really significant conceptual difference from the way we in the US, at least at the national level, have thought of data privacy and of the ability to bargain away effectively information about yourself. So, the terms of services of, let's just stick with, the sports betting app that would relate to you here in the US are generally going to say that the information that's collected, you have, turned over to that entity, and effectively, they own it because by contract, because you've given it to them. And we really don't view it as a personal property right, the way we view other pieces of personal property. Like, I'm just picking up my reading glasses here, right? I own these. It's my personal property. I can sell it or not. It's a very different kind of thing. Whereas the European view really does view it more as personal property, which means, you as the controller or processor are more like a fiduciary. You're more like holding my property for a period of time that I can get it back. All right. The right to object is related to the right to restrict. So I can restrict or I can object and say stop processing entirely. And again, there are exceptions in the details of the GDPR. You can imagine that there's circumstances under which a controller or processor can't simply stop on a dime. And there are circumstances in which the controller or processor has their own legal obligation, for example, complying with lawful criminal investigative process. And those details you would need to know for the CIP-E. And a right not to be subject to automated decision making. And this is a really interesting and controversial one. And again, it's being taken up in some of the US state legislation. So automated decision making, algorithmic decision making, at a larger scale. Our algorithmic decision making is something we call artificial intelligence. It's not general artificial intelligence. It's not a sentient being. We don't have that and probably never will. But at a very large scale, the ability to process large amounts of data to make decisions. So predictions, for example, like Amazon saying, here's a book I think you'd like, or Netflix, here's a movie I think you'd like, or at much more sophisticated levels than that. Under GDPR, you have a right, again, subject to some exceptions. The subject has a right to object to. All right, another piece you should know about for the purpose of this test, for comparison purposes, is the breach notification provision in GDPR. So GDPR defines what a data breach is. In the lingo of data security, and again, this is a place where data security relates to data privacy. And you heard this, I think, a couple times during the day, maybe sort of passed by a little. An incident, a data incident, means that your system has been in some way compromised. You've realized there was a phishing attack, and maybe some malware has infiltrated your system. That's an incident. A breach means that something has been disclosed as a result of the incident. So not every incident is a breach. Many incidents are not breaches, but some incidents are breaches. In the US, you have obligations under the laws of all 50 states to do reporting to the data subject whose information was taken. And as we've heard, those can really vary widely. In the EU, you have an obligation under the GDPR, right? So breach leads to some loss of data. A data controller, and this is a place where a controller and a processor has a somewhat different obligation under GDPR. The controller, even if you are using a processor, even if the breach happened to the processor and not to you, the controller, but you have an agreement with the processor and you are the controller, you have 72 hours to report to the DPA in the relevant jurisdiction. And if you get into the weeds again for SIP-E, you'd have to sort of have some understanding of what jurisdiction you'd have to report to. Don't worry about that now. Just worry that you know that you need to report. 72 hours is an incredibly short turnaround window. Most of the state data breach laws in the US give more time than that, to the extent they even give specific time frames. So there's a lot of decisions that have to be made, within that very brief time frame. So that's to the DPA, and then to the data subject, so to each individual whose information was taken without undue delay, if there's a high risk to their rights and freedoms. And as you imagine, right, that's the DPO and others within the organizations are going to have to decide what all that means, partly based on, to whatever extent that's fleshed out in case law in the EU. The data processor obligation is to notify the controller without undue delay. Again, whatever that might mean in the case law, and then that notification to the controller will, of course, trigger the controller's obligations to make further notifications. GDPR remedies. The scheme of the GDPR is really a regulatory enforcement scheme through regulatory requirements and fines and penalties. And the controller and processor can be liable to the data subject for specific harm that is caused to the data subject. And the controller and processor can be liable for fines and penalties that can be really hefty. Up to 4% of an entity's global revenues for a incident of non-compliance can be pretty significant. Global data flows, and I mentioned this is a place you want to bear in mind, because this is a definite intersection between SIP-US and SIP-E. So if and this relates to data that is flowing either from the EU into the US or vice versa, that relates to a European data subject. And this is a way in which the GDPR really has extraterritorial effect. So the processor or controller does not need to be located within the EU, within an EU jurisdiction, to be subject to its requirements, so long as it is controlling or processing the data of EU data subjects. So what if the processor or controller is located outside of the EU? How does that work? Well, if you are in a country where the data protections of that country have been deemed adequate by the EU, then there's not much else you need to do. You simply need to comply with the national law of the jurisdiction that you are in. There are only a handful now of jurisdictions that have received an adequacy determination, which, not surprisingly, does not include the US. And one core reason why is because we don't have comprehensive federal data protection regulation. The US has tried a number of times to come up with a sort of voluntary compliance mechanism whereby a company could comply with certain standards and then receive some kind of certification or something along those lines to show that, even though the US doesn't have this comprehensive regime, we've at least done this voluntary compliance and gone this extra step, and that should be okay. And a couple of times the US has tried with this. Most recently, I think you've heard a couple times the term Schrems 2 thrown around. So Max Schrems is a German citizen who's on his own behalf, brought litigation in the European Court of Justice and in national DPOs about compliance with GDPR. And in the most recent case, Schrems alleged that the last iteration of the US's effort to provide some mechanism that would be acceptable to the EU was inadequate. And the European Court, in fact, found that the US's mechanism was inadequate. And the main reason for that finding of inadequacy is something that you heard a real brief reference to. I think Carrie mentioned it briefly, which is the FISA statute. So the surveillance regime that the US put into place after 9/11 through the Patriot Act, which included some amendments to the FISA statute, and you don't need to know any of the details about that, but know this broad concept. Allowed the US to conduct a pretty broad net of internet surveillance without a search warrant. So there's a certain kind of court order that has to be obtained, but as Carrie mentioned, it's a top secret court. It's really not an adversarial proceeding. The standard is significantly below that of a search warrant. Now, the FISA statute, as Carrie mentioned, has been amended a couple of times, and as of the time of Schrems II, the US was arguing that it should be acceptable now, but the court in Schrems II said it is not, that's a significant reason why the US effectively can't be trusted. Now, many observers, and I think I would probably include myself in this, see a lot of politics behind the decision in Schrems II. The fact is, every country in the EU is also doing extensive internet surveillance. Every country in the EU has surveillance authorities short of the equivalent of a search warrant that are very comparable to what the US does under FISA. Some of the EU countries actually have more extensive internet surveillance and limitations on speech than the US does, but it is what it is. That's the ruling right now. And really, I think a lot of it is about the fact that an effort by the EU to pressure the US to adopt a national comprehensive regime that would be similar to GDPR, which we just haven't done yet. So what can you do? Well, I know that several of our speakers over the past couple of weeks in their organizations have been working very hard on finding alternatives so that their entities can safely engage in cross-border data flows. So there are ways in which a company can adopt certain rules that apply to the way the company does data flows. There are data protection clauses that are approved within the EU that can be used. There are other certification mechanisms. With individual transactions, there can be a derogation that's really not, that reliable because it's just an individual transaction. So many companies are working along these different lines to try and figure out what to do. You don't need to know all the details now, but know that in the absence of adequacy determination, which we don't have in the US, one of these other options would have to apply. So I'm going to give you now just a fairly quick comparison of GDPR to the California law, and then conclude with an even quicker comparison to Virginia and Colorado. The California law is not tested in detail on this test, but you may get a question or two that refers to the California law as an example of a state with a comprehensive law that is similar to the GDPR. Now, the CCPA and the CPRA is sort of an amendment to CCPA that did different things with it. Is a comprehensive rule. It is cross-sector. It has some carve-outs for healthcare and for some other things that are governed by a specific federal law, but it applies regardless of the industry you're in. But of course, it is a state statute, not a federal statute. And of course, and that then raises questions about its extraterritoriality and who exactly it applies to. So the California statute, as amended by the CPRA, defines it this way: a for-profit business processing data of California residents and either has revenues in excess of 25 million, obtains personal information of 100,000 or more California residents annually. That was 50,000 under CCPA, and it was bumped up to 100,000. Or derives 50% or more of their annual revenue from selling or sharing California residents' personal information. So this sounds, fairly restrictive, but if you think about it for a moment, it's really not. Of course, many companies are going to be in this size range. Most of the larger companies in the U.S. are going to be in this size range, and if they are, it's quite likely that they're processing data of at least some California residents. So that's going to scoop up a lot. As I said, this one was bumped up from 50,000 to 100,000, and that was, supposed to be sort of making the statute a little less onerous for some small businesses. But, if you're doing business online and you're using, say, cookies, you're potentially collecting PII of some of your data subjects, and 100,000 hits annually isn't necessarily that much. And then this piece actually was significantly expanded by the CPRA. This used to say only selling. It was expanded to add sharing. So what's the difference? Selling, you're sort of brokering the data. Sharing, you could be disclosing the data to any third party that might be doing something on your behalf, and then you can fall into that. And the question would be, what do you actually derive revenue from? Yet to be seen exactly how the regulations and any litigation might play out under that. The rights under CCPA, as you can see, are very similar to those under GDPR, including a right to deletion, right to receive information, right of access, notice. The really key difference, CCPA is an opt-out or opt-in regime. So it is possible to comply with CCPA through opt-out, whereas, of course, with GDPR, generally speaking, you need opt-in. Some things that are not covered that are carved out of CCPA, like GDPR, government legal process, you have an obligation to comply with. HIPAA and GLIBA information is carved out. And why is that? Because HIPAA and GLIBA govern that, and there are potential preemption questions there. Now, that doesn't mean that all health information is not subject to CCPA. It doesn't mean that all financial information is not subject to CCPA. If you were trying to comply with CCPA, you'd have to be really careful about specifying, well, what is really HIPAA and what is simply like if I'm doing a health tracker and it's collecting information about the person's heart rate. It's probably not HIPAA information. You're probably still covered. You don't need to know all those details, but just know there are some of these carve-outs. And then, of course, anything that doesn't fall within the coverage of the statute isn't covered. All right, my last slide on this, and then we're gonna wrap up. As I think Carrie mentioned, the Virginia statute, which is relatively new, the Colorado statute, which is relatively new, probably are not going to be on this exam specifically. But it is possible you might get a question or two that reference them. And really, I think the key thing for you to have a feel of now is some of the differences between Virginia and Colorado and California. So as I mentioned, California is opt-out. Both California and Virginia and Colorado all have specific definitions of sensitive personal information. In Virginia and Colorado, sensitive personal information is opt-in. Now, you can imagine, right? You're working in this field. This is part of what makes it fun, but also complicated. Now you've got U.S. federal sectorial laws. You've got potentially the GDPR, and then you've got at least 3 different states that you might have to comply with different obligations. All of which is, as you might be thinking, means you probably need to find the most restrictive that likely applies to you. It also means, and comply with that and hope you're complying with the others. And it also means that, compliance is a best efforts thing. It's never exactly perfect. All right. And then the other thing to just notice is the jurisdictional trigger. And they're similar, but have differences. So the California one we mentioned, Virginia targeted to residents of the Commonwealth. That's potentially even broader, especially if you're doing business online. The 100,000 threshold, and then process of at least 25,000 and derive over 50% revenue from sale. That's potentially a little narrower than California. And Colorado is basically similar to Virginia on the 100,000 limit, but is different on the revenue threshold. So, there's a lot of different moving parts. And, as was mentioned a few times during the day, there are always new state laws coming out. New York seems to always be on the threshold. New Jersey seems to often be on the threshold. Many other states, this is really becoming a trend. So you're going to be seeing more over the next few years, I'm sure, if we don't see a comprehensive federal law that preempts. For now, for this exam, just realize these general parameters, have a sense of some of these differences. And if you get a question or two about it, you'll be ready at least to make a good educated guess at the